County Attorney.
I got some questions.
We all do on this one, I have a feeling. Commissioner Ellis?
Yeah, so on item 17E, on additional attorneys on the bail lawsuit, how much have we spent so far?
We've spent approximately $2 million, Commissioner, the county has, on representing the judges, the sheriff, the hearing officers, the county.
So it's $2 million now, which is, I think that's about the amount of money we got from the coveted MacArthur grant.
I don't know, Commissioner, that sounds right.
Okay. If, well, where are we now? Are we at, this is the, we on the injunction phase, right?
Yes, we have completed the hearing on the temporary injunction, and the county, the plaintiffs, and the judges are awaiting a ruling from the federal court judge on the temporary injunction.
So it's $2 million on a temporary injunction, and after the temporary injunction, if it is granted, or if it's not granted, we would then go to a trial.
Potentially, or one side or the other might choose to appeal at that point.
If the county loses at this phase, I know when I read the initial filings, the lawyers for the plaintiffs were not asking for legal fees, but do you know whether or not they would be eligible for legal fees?
I do not know, Commissioner. And that certainly starts getting into strategies and consultation with the county attorney that might best be handled in executive session.
Is it common to go and name an appellate counsel before the hearing on the merits of the case or before the judge has ruled? I mean, does that?
Yeah. In all major cases handled by the county attorney, there is an appellate counsel assigned pretty much at the beginning of the case, and particularly when we get to any hearing. And in this particular case, there are already appellate counsel assigned to the case. This is an additional appellate counsel who would do some of the work that would otherwise be done by other appellate counsel. The other thing I want to stress to the commissioners is that there has been no decision to appeal the case, not appeal it. It's simply to be ready to deal with eventualities. Whether the county decides to appeal, the plaintiffs decide to appeal, but it's sometimes good to have these things lined up in advance. The other thing I would stress is that there is no money being paid out until this additional counsel does work on the case.
Or until there's a ruling? Or do you know the clock would start ticking?
The clock starts ticking when the county attorney requests that this additional attorney does work.
Do you anticipate keeping the other attorneys as well?
Yes, sir.
So this would be an addition, this would augment.
It would augment, perhaps replace some of the appellate counsel that currently work for the Winston law firm.
And who picked this attorney?
This was recommended by the county criminal court at law judges 1 through 15.
And who is this attorney?
This is Scott Cooper. I'm sorry, Chuck Cooper.
I'm just curious, does your office look into his background?
Yes, sir.
I'm concerned because when I looked at his background in the middle of the night, I know that he is the attorney who represented, I guess, the defendants in the Bob Jones University case, which, if I remember correctly, that is where the argument was being made that they did not have to integrate that great university because it violated religious convictions. You're aware of that?
I'm not aware of that. We are aware that this man is eminently qualified to handle this type of case, and that his firm traditionally represents local governments in these types of cases involving constitutional rights and civil rights.
So
that is his field of expertise.
Yeah. When I looked it up, now I admit I looked it up in the middle of the night. But I saw where he was the counsel arguing against California's vote initiative that said they could do same-sex marriages. And of course, he lost that one at the United States Supreme Court. But it looked like when I went through it, cursory review late at night, that he's one of the leading experts on fighting civil rights cases. In fact, his name came up to be appointed by President Trump to be Solicitor General. And in part, the controversy that came up over the Bob Jones case led to him withdrawing his nomination, at least from a cursory look of the internet.
And
Were you aware of that?
I cannot say why Mr. Cooper chose to withdraw his name as a potential appointment to Solicitor General of the United States, but certainly the fact that he was considered and was considered to be qualified for that appointment would indicate that he's qualified to handle an appeal of this type of case.
So now, what I saw something, it appears as though Mr. Cooper would be representing judges maybe 1 through 13 or 1 through 14.
It's the county criminal court at law judges 1 through 15.
So what about if Judge 16 came in and asked, since he is being sued as well, to get appellate counsel, would your office also recommend that that judge be given appellate counsel? Or is it only for the other?
No, it would be each case. I mean, we have to look at each request and make a determination based on the request and based on the qualifications of the person that the elected official requests represent that person. It's a case-by-case situation. So far, the judge of County Criminal Court at Law number 16 has not requested outside counsel.
Who's representing that judge?
An attorney in our office represents that judge.
But just hypothetically, since 1 through 15 are asking for, as you stated, you consider eminently qualified Mr. Cooper. If Judge 16 asks for Eric Holder, who I assume one would say is eminently qualified as well, then your office would move forward a recommendation, and we'd be asked to vote to pick up that tab as well.
Well, that's a lot of hypotheticals. First of all, we have to assume that Eric Holder would want to take the case. We also have to assume that he has time to do it and that he would work at the same rates as the other attorneys. But that's a hypothetical, and I should resist answering hypotheticals. We don't know what the situation would be. We don't know who Judge Jordan might request.
But your office makes the final decision.
Our office, the Harris County Attorney, appoints outside counsel. This Commissioner's Court approves the contracts with outside counsel.
But we cannot do it without your permission, I guess what I'm asking.
In our view, the county attorney is the one who appoints outside counsel. Commissioner's Court approves the contracts or disapproves the contracts. That's within the discretion of the court. But also, when you have an elected official who is a defendant in a major lawsuit, the Harris County Attorney's Office gives deference, asks for input from the elected official. It's not simply one person making these decisions. It's a whole bunch of folks working together to do what's best for Harris County.
So you have the judges, the sheriff is a party, or was he dismissed? The sheriff
is still a party.
So if the sheriff asks for outside counsel on the appellate level, you assume you give that the same deference in terms of a recommendation from your office?
We would consider a request and give it the same deference. I can't say what the recommendation would be. Again, we're dealing with hypotheticals.
Would there be some, in your judgment, irreparable harm if I were to delay this for 2 weeks?
Irreparable, no. I mean, irreparable is a big word.
Does it create a problem?
It's a 2-week delay, in my judgment, would not be irreparable. You know, whether there's harm or not, it depends on circumstances beyond our control or beyond our knowledge.
Does it trouble you if it's delayed for 2 weeks?
I don't know that it matters if it troubles me or not. I mean,
It is in terms of your
not
legal.
my
In
concern
terms of
in
your
any
legal.
way.
Yeah, in terms of your legal.
I don't. I
Your legal
hesitate to
strategy.
answer that question in open court. That's more that's more a legal strategy that really needs to be dealt with in an attorney-client privileged communication.
I just don't know. I'll let it go.
May I ask a couple questions?
Sure.
The role of an appellate counsel is to be on deck to make sure that all deadlines of a decision are met, correct?
Correct.
To appoint someone after deadlines are being missed sort of defeats the purpose of having appellate counsel to make sure that your appellate deadlines are met.
There's a potential issue with that, but I would again state that there are appellate counsel already retained within the two firms that are handling the two outside counsel firms. And in fact, there's appellate counsel within the office of the county attorney also.
And the second feature of appellate counsel is to make sure that you make the correct decision of whether or not to appeal.
Yes, sir. That's vitally important.
So meeting deadlines and making a decision as to whether or not there is something that is appealable or something that needs to be defended are important features of appellate counsel.
That's correct.
Those are my clarification questions. Thank you.
Just one more.
Y'all have any questions?
Yeah, real quick, Mr. Sword.
Not
Just
all the lawyers in Commissioner's Court.
we've got to get a word in. Just to be clear, after there's a decision by the judge on the preliminary injunction, either side potentially could do an interlocutory appeal.
That's my understanding, yes, sir.
Okay, I just wanted to make sure. That's it.
How many appellate lawyers do you have?
Wait, you didn't give Commissioner Raddick his turn.
Oh, Counselor.
I'm just yielding my time for this for a few minutes, and I might have something to say. Y'all go ahead.
Glad we're working together. I knew we'd get there.
Hell, you're the one that begged these lawyers to sue us to begin with, and now you don't want us to defend ourselves. It's just like unbelievable. I mean, I worked with L. Franco Lee. We have been working on bail bond reform. We've been working on indigent defense. I think we've made a lot of strides. But I mean, hey, if you got buddy lawyers that want to sue us, fine. That's what they did. But I'll be damned if we're not going to defend ourselves. Go ahead, I'm not through.
Thank you for your comment. I think Harris County has made tremendous strides.
Well, thank you for that.
But I
While
think
you
that,
are up hanging around in Austin, figuring out a way to pass unfunded mandates for Harris County and creating an indigent defense law where you didn't bother to fund it. And then you say we never asked for the money. No one did. Turned out that wasn't true. We've been asking for it for 10 years. So go ahead.
yeah, I'm very proud of that Fair Defense Act. And in fact, I think that most legal experts would say it changed the face of criminal justice in Texas.
Unfunded. It sure
And
did.
but we'll get there. We're gonna get there at some point.
If I
Hand
could-
in hand, you and I could help get some money working together.
Well, let me interrupt this colloquy here for a minute and ask the county attorney a question. Fundamental question. The way Harris County has conducted itself in these matters with regard to bail bond, are we different than any other county in the state of Texas?
In
In other words, are we being sued because we're unique, or are we being sued because we happen to be the biggest county doing it the way all the counties do it?
I hesitate to answer the question because I don't know how they do it in other counties, and I'm not that intimately, acquainted with all those procedures. And why we're being sued is, I guess, we can only speculate. Certainly the fact that it's one of the biggest counties in the United States, we believe, plays a role in why Harris County was a target.
And if you tell me that this needs to be executive session, that's fine. Without condoning the practices, are the judges following state law?
I think we ought to talk about that in executive session.
Okay. Because,
And I don't want that to be interpreted
No, I
as a
understand.
yes or no answer to that one way or the other.
because what is troubling, and I know this would be executive session material, is we keep hearing from all sides that, gosh, we all want to settle, but nobody seems to be getting there. So at some point, you know, we're going to have to either play this out or come to a settlement. And I'm not sure that all sides really do want to settle. I think there's a lot of conversation, but when it comes down to getting everybody in the same room, I just think there are a lot of other things at play here. So, but Harris County is not unique. I just want to put that on the record, that that's not defending what's been done. I don't think anybody agrees that somebody should be kept in jail just because they're poor. But at the same time, to single out Harris County and to continue this, just it raises questions. And I'm sure that will come up in an executive session.
Couple more questions. If at some point there was a settlement, would your office still recommend that the county pay for lawyers for the judges? So if the sheriff agreed, if that was language, or if that's the subject for executive session, gentlemen?
That would be a subject for executive session.
You want to go into executive session?
And
Might be
that's
helpful.
strictly up to the commissioners.
Okay.
I think it might be helpful.
Any objections? We need to state,
You just state that an executive session is necessary to consult with the county attorney on this particular item.
okay, that's item 17E on page 13.
And then, Judge, we also have another executive session item, and it might be you want to announce that we're going to executive session on that one, so we only make one trip.
Okay, and that is request by the county attorney to authorize a special counsel agreement with Kroger Burris in connection with Cassandra Salcido versus Harris County, which is another case pending in the U.S.
Yes,
court.
sir.
Okay,
You need a vote for a necessity on the first one?
I'm sorry, on
Do you
the,
need a vote on the necessity of an executive session on the first one?
on the first one, there needs to be either a vote or by common consent.
yeah, I was doing it without objection, but if there's objection to going back, we can vote.
It is the province of the Commissioners Court to have an executive session.
All right, at 11:07, Harris County Commissioners Court will come back into open session. We were on page 13, item 17E, under the county attorney.
Judge, item E, request to retain additional counsel as recommended by the Harris County Attorney. I move to approve.
Is there a second?
Second.
Discussion. Let's be clear, this person doesn't get paid at all unless there is an appeal. Is that correct? That's everybody's understanding?
Well, to clarify slightly, he doesn't get paid until he's asked to do some work.
Right.
And it is certainly possible he'll be consulted on whether an appeal is needed.
And it's the county attorney's recommendation that this is the person to hire?
Yes, sir.
Okay. Any further discussion?
Judge, I think I made my position clear on it, but I know the votes are here to move forward, so I'll just respectfully vote no.
Well, when I call for the vote, you can do that.
Okay.
All in favor signify by aye.
Aye.
Any opposed?
No.